Hi, my name is Susan Im of ImLaw. I have practiced exclusively immigration law for over 15 years. Today's topic is the H-1B work visa. What is the H-1B? Well, it's not a disease. It's actually the work visa category that is most popularly used by professionals desiring to work in the United States. It is also used by foreign students pursuing their studies in the United States desiring to work for a U.S. employer. The H-1B requires a U.S. employer to sponsor the foreign national for H-1B status. And a U.S. employer must be operating in the United States and must possess a valid federal employer identification number. It also requires that the employer is offering a position that qualifies as a specialty occupation. What is a specialty occupation? Well, the U.S. Citizenship and Immigration Services states that the specialty occupation is a position that requires a bachelor's degree or equivalent in the relevant field. It's important to focus on equivalent because oftentimes the foreign national does not possess a 4-year U.S. bachelor's degree in the particular field. Maybe it's a foreign degree that needs to be evaluated to be the equivalent to a U.S. bachelor's degree in the relevant field. But also, foreign nationals can qualify for equivalency based on a combination of college or university education together with progressive work experience. And in certain cases, foreign nationals can qualify on progressive work experience alone. The offered salary by the employer must meet prevailing wage requirements as determined by the Department of Labor. There are also some mandatory fees associated with the H-1B, in addition to an attorney fee, if you're working with an attorney. In addition to the normal petition filing fees, there is a mandatory employer training fund fee of $1,500 or $750, depending on the number of employees in the employer's organization. And there is also a mandatory $500 fraud fee that must be included with every initial H-1B case. And finally, the foreign national must possess the bachelor's degree or the equivalent in the required field. So backing up a little bit, we talked about how the employer's position must require the bachelor's degree or equivalent in a field relevant to the position. But in turn, the foreign national must also possess that bachelor's degree or equivalent, and we must prove it with each filing. One document that must be filed and certified by the Department of Labor prior to the filing of an H-1B case with the U.S. Citizenship and Immigration Services is known as a Labor Condition Application, or an LCA. What is an LCA? It is a document that is filed with the Department of Labor that contains several attestations by the U.S. employer regarding the hiring of that foreign national. Some of the attestations include one that the employment of the foreign national will not adversely affect the employment of other U.S. workers, and that the foreign national will be paid 100% of the prevailing wage. Notice of the LCA filing must be posted at the work site for 10 calendar days, and that's the labor condition application. The final critical issue with regard to H-1Bs that I want to cover today is the cap. Decades ago, Congress set a limit of 65,000 H-1Bs per year, and we've run out of visas every single year. There is additional 20,000 H-1B visas reserved for those who possess U.S. master's degrees, and interestingly enough, the USCIS has not limited applicants to having to possess the master's degree in the relevant field. What employers avoid this H-1B cap? Well, certain fortunate employers such as nonprofit higher education institutions, nonprofit organizations that are affiliated with higher education institutions, nonprofit research and federal government agencies, and certain for-profit organizations that employ H-1Bs who will perform all or most of their duties at a site, on-site at a qualifying organization such as a higher ed institution. And finally, this is a scenario that comes up very often. Employers filing H-1B transfer cases for foreign nationals already possessing H-1B status through another employer. H-1B transfer cases, as long as the foreign national possesses valid status and the petition is otherwise approvable, the H-1B transfer cases are not subject to the cap. Another big benefit of the transfer cases is that the foreign national may start with the new employer upon the proper filing of the transfer petition. They don't have to wait for approval like everyone else. The duration of the H-1B visa. It's valid for 3 years at a time. So the maximum that an employer can request on an H-1B petition is 3 years for a maximum of 6 years. Now, there are a couple of exceptions that Congress has carved out for employers. One can file an H-1B extension beyond the 6-year maximum if, in that case, the employer has filed what's known as a perm labor certification, which is the first stage of most foreign nationals' employment-based green card processes. If they filed that perm labor cert application with the Department of Labor at least 365 days before the foreign national's 6-year max-out date. If that condition is met, employers can file 1-year extensions of H-1B status indefinitely beyond the 6-year max. Secondly, a 3-year extension can be filed for an H-1B beyond the 6-year maximum if, once again, the employer has filed a perm labor cert application, started the green card process for a foreign national, has received approval of that application, has moved on to the second stage of the green card process known as the I-140, received approval of that stage, and lo and behold, the foreign national cannot move to the third and final stage of the green card process because there is complete unavailability of green cards for their employment-based category. And again, this stems back to congressional limits set decades ago that have not kept up with the current economic conditions. That's it for H-1Bs today. My name is Susan Im. For more information on H-1Bs, contact us at imlaw.biz.